Hello, and welcome to the Arbitration Conversation. So in this arbitration conversation, we are talking to a true expert, Professor Erin Archerd. Erin, thank you so much for coming.
Hi, glad to be here.
Absolutely, and she is at the University of Detroit Mercy in Detroit, Michigan, very busy. She's also the chair of the Ethics Committee for the American Bar Association, and has been doing some really interesting work across the board. So it's great to get a chance to have an arbitration conversation with you, Erin. I guess to start off with, we had decided the topic for the day is going to be ENE. So before we of course as ADR people love our acronyms. So what is ENE?
So ENE is called Early Neutral Evaluation. That's what it's short for. And it's a process in which you might reach out to a neutral to have them essentially give an opinion or decide an element of a dispute, prior to bringing it to court. I mean, it could be as part of a court process, if you're trying to resolve claims before you actually have to go to trial. And the reason that I became interested in this actually has a little bit of a tie to a process that's very much like arbitration that we have here in the state of Michigan. So I'm based in Michigan, and in Michigan, we have a process called case evaluation. And so case evaluation is something that happens when you are bringing a case to trial, and almost all tort cases and really many, many civil cases in Michigan have this three-person panel. You go in front of the case evaluators, they give you sort of value for your case, and you have to do that process before proceeding to trial. So it's sort of like a non-binding arbitration.
What are some examples of areas or contexts or types of cases that might be subject to that?
A lot of personal injury kinds of things will go there. But really any civil dispute in Michigan could be referred by courts to case evaluation. So you could see it in business disputes, for instance, business litigation. What has been happening over the last, I would say, 10, 15 years or so has been a shift in focus in our sort of state court dispute resolution towards more of a mediation focus. And so a few years back, really 10 years back, and then a follow-up study were convened where they found that lawyers and judges actually were preferring to use mediation rather than resolving the disputes in case evaluation. So the way case evaluation works is, this advisory arbitral panel gives you a number, and the plaintiff and the defendant get to decide, do I take this number? Mm-hmm. Mm-hmm. And it used to be that plaintiffs and defendants would say, yeah, we'll take that number, and that would resolve the case. But more and more, that hadn't been working. And so you saw parties go to case evaluation and then go to mediation.
Oh, I see.
Right, and resolve their case in mediation. And so what has arisen out of that has been that the state has actually been exploring, do we want to scale back case evaluation and encourage more mediation?
Right.
And so that's sort of how I got interested in this idea of early neutral evaluation, because there is still, I think, this desire on attorneys' parts to have somebody, who's coming in and giving an opinion about what a case is worth. Mm-hmm. And my concern as a mediator, and as a mediator that, like many, largely tries to be facilitative, is that I'm going to have, more parties asking me, well, what do you think my case is worth?
Yeah.
And, I know this is arbitral focused, but, you probably had people talking about the difference between an arbitrator and a mediator, which can get fuzzy.
Yes.
But, my preference would be that attorneys give more attention to this idea of hiring an early neutral evaluator. Mm-hmm. If they think that kind of figure would really be useful to have for future negotiations around settlement.
Right. Well, and the worry, if it's the same individual who's supposed to be a mediator who's giving this evaluation, well, then you might have an anchoring bias you can have an issue where people feel as though, oh, well, then that's how this really would come out. But what if that mediator is wrong, right? And what if their assessment was not even anywhere near the ballpark, but it seems as though it's got that kind of stamp of approval. So there's a lot of worry there.
Yeah, and there are good ways as a mediator to give a mediator's proposal.
Mm-hmm.
But I think that mediators need to be really clear with the parties in advance. Either I am a mediator who gives mediator proposals, but if I do, I'm not going to do it until the end, and then we're done.
Yep.
So that it doesn't create things like this anchoring bias. It doesn't raise concerns about the neutrality, and really, once you go figure as a mediator, it damages your neutrality with everyone.
Right. Well, and the thing is, like you said earlier, as well as what attorneys want if they're representing a party or in a business case, they actually want you to provide some sort of guidance, especially at the end when they just need that last nudge, right? And sometimes that can be really important for the attorney, right? Because sometimes it's even a matter of the attorney making sure that her client understands maybe the case isn't as fantastic as the client may think.
Yeah, I wrote a piece about this as part of the discussions and dispute resolution project. And I do think that one of the things that lawyers are doing is they're sort of shifting to the mediator a lot of times, the sort of responsibility for client counseling.
Yep.
And that providing this number is a way for mediators to be counseling the clients in lieu of the attorney. That's not necessarily a bad thing. I mean, that's good for mediators who want business.
Right.
But
it's taking, but that's that's a really great point. I mean, because that is part of client counseling, which often, in my opinion, is sometimes overlooked in law school, but it's such an important part of a lawyer's job.
Yeah, and I think that one of the things that we need to do is be better about educating the public about sort of what is the range of attorney roles in dispute resolution, because the zealous advocate role tends to get really played up, especially in popular culture, when I think people who've been in practice for a long time know that the client counseling role is really, really critical and an important value that attorneys are bringing to a dispute.
Yep.
And so I actually think, and I'm sort of straying from our original topic of early neutral evaluation, but one of the points that I made in this discussions and dispute resolution piece is I actually think that lawyers are trying to take back some of this, client counseling that's been ceded to mediators in a few sort of key areas of the law. Family law is a big one. So if you look at collaborative law, collaborative legal practice, I think that's a way that we see attorneys really signaling we're client counseling, we're settlement focused, we don't need a mediator. Because if you get attorneys with the right mindset, they can do it themselves. But you're not seeing the collaborative lawyering happening as much in tort or big commercial cases. I mean, it's largely, at least as I've seen it, confined to family law. But it's interesting. And I think, in terms of, are there lessons for arbitration? I think that maybe the lesson is neutrals wear a lot of hats, right? So you have people that serve as arbitrators. At least here in Michigan, we see them largely serving as mediators as well. So my proposition would be, think about, is there a way to build out your practice also as an early neutral evaluator, right? Helping parties place value on settlement, or maybe not settlement focused at all, right? It really depends on sort of the question that you bring to your early neutral evaluator. One figure they could give you is, well, what's the settlement value of this, as opposed to, well, what do I think the actual value of this would be in litigation? Those numbers might not be the same.
Yeah. Well, and I think, really, this whole conversation has really given us a nice really bird's eye view and thinking about the spectrum, as you said, that neutrals may have. There's early neutral evaluation, there's arbitration, there's mediation. There's a lot of different hats that an individual, the same skill set, can actually serve a lot of different purposes.
Yeah.
Really good. Yeah. Well, listen, thank you so much for taking time. I could talk to you all day, and I look forward to a conference where we can be in person and have coffee.
Yes, I would drink any beverage with anybody at this point in time, just to be able to be face to face.
Absolutely. Thank you so much.
Thanks, Amy.